Individuals with Disabilities Education Act, IDEA. It's estimated that 15% of all children in the U.S. have a disability, whether cognitive or physical. The Individuals with Disabilities Education Act that was passed in 1975 entitles every child with a disability to a free and appropriate education from infancy to young adulthood through early intervention and special education services. The federal government requires schools to serve the educational needs of eligible students with disabilities. There are about 13 that I won't list. If a child does not qualify for special education under the terms of IDEA, they may under Section 504 of the Rehabilitation Act, which is a little bit broader than IDEA. It may include accommodations for a student or changes to a learning environment. Schools must find and evaluate students suspected of having a disability at no cost to parents. This is from infancy to age 21. Early intervention may be supplied through the Child Find program. Child Find is a community-based program funded by the federal government that uses all possible social, medical, and community-based personnel to locate any child that may be eligible for services. This would include any transient population and migrant workers. Once a child is identified as needing special education services, the school must provide them FAPE, which is a free and appropriate public education, and related services such as speech, occupational therapy, and counseling. This is designed to meet the unique needs of these children and help them make progress at school. IDEA also is designed to give parents a voice in all of the educational decisions made by the school on behalf of their child. This includes, but is not limited to, the writing of the Individual Education Plan, or IEP. Only states receiving federal funds for special education are obligated to provide these services, though that is a moot point because all states opt for special education services, so they're all receiving funds. Parental rights under IDEA, the rights of a parent to receive a complete explanation of all the procedural safeguards available under IDEA and the procedures in the state for presenting complaints. Confidentiality and the right of parents to inspect and review the educational records of their child. The right of parents to participate in meetings related to the identification, the evaluation and placement of their child, and the provision of FAPE, a free and appropriate public education, again, to their child. The rights of the parents to obtain independent educational evaluation of their child. The right of a parent to receive prior written notice on matters related to identification, evaluation, or placement of their child. The right of parents to give or deny their consent before the school may take certain actions in respect to their child. The right of the parents to disagree with decisions made by the school system on those issues. And the right of the parents and schools to use IDEA's mechanisms for resolving disputes. Okay, one of the most famous Supreme Court cases was Henry Hudson Central School District versus Rowley. This was when a little deaf girl was doing great in her class. Her parents thought that she would even be able to do better if she had her own sign language interpreter there, or someone to give the sign language. The court ruled against that and said that free and appropriate education wasn't quite identified when the Congress wrote it. So an adequate could be just a girl progressing throughout her, she didn't need the extra stuff. She was doing fine as she was. Let's see, in 2001, George Bush, No Child Left Behind, ushered in a new era of expectations and accountability, including scores of special needs kids and overall data related to funding. So in other words, suddenly educators had to pay a little bit more attention to kids with special needs because it was going to be included in their funding. This has been attributed to strict accountability provisions for the students with disabilities. But on the downside of that, many special educator teachers saw extra pressure being brought on the kids. And some of them were emotionally, had emotional issues to begin with. The IDEA also gave us the law regarding a least restrictive environment, that your child is eligible to be, a child with disabilities is eligible to be educated in a class with their peers, which science has proven that that's the best way. That's how they flourish. That's how kids do best. So in other words, least restrictive environment means that a student who has a disability should have the opportunity to be educated with non-disabled peers to the greatest extent possible. There is a problem now in special education law up to date. We have Betsy DeVos, who's been appointed by Trump, who is completely unqualified for the job. In her hearing when they were with the Senate, she really wasn't even aware that it was a federal mandate for special education. Now, I talked earlier about the Howley case, where it was determined that an adequate education was free and appropriate. Now, Chief Justice John Roberts just recently said that children with disabilities were actually eligible for more than just an adequate education, just like their peers in the same classroom. So, good news for special education, and a good decision by Roberts. That was in the case Andrew F. versus Douglas County School District. Roberts said, "It cannot be the right that IDEA generally contemplates grade level advancement for children with disabilities who are fully integrated in regular education classroom, but is satisfied with barely more than the de minimis progress for children who are not." That was Roberts. Good job. Thank you. Bye.